Hi everybody, so I'm speaking this mic to record, not to amplify. So this is gonna be a really weird effect for people here sitting in the room. My name is Satish, I'm from Columbia Technology Ventures, one of the groups hosting this event along with Mintz Levin. Just a quick 30 seconds on our office. We are the commercialization office at the university. We manage intellectual property. We try to find commercial partners to help you take your technologies, if you're a researcher at the university, into the marketplace. We do this traditionally through licensing, licensing to corporations, licensing to startups. The emergence of startups is definitely growing very fast at Columbia University and as well as New York City. And this is why a topic like today is very relevant for a lot of people in the room. Just want to remind you that CTV is definitely a lead in terms of helping startups get off the ground, but there's plenty of resources on campus through Columbia Entrepreneurship as well as New York City. This is a great time on campus and in the city to launch a startup. Lots of city or state funds trying to fund entrepreneurs, trying to take things out into the marketplace. A lot of companies and venture capital firms coming into the city, pouring dollars into the city, as well as our campus as well. So if you have a technology, if you're a researcher here, or you have an idea, definitely go look up Columbia Entrepreneurship or Columbia Technology Ventures to try and find some more information and hopefully to work with us. So today I'd like to introduce Dan DeWolf and Sam Effron from Mintz Levin. I'm going to do Dan's intro. I'm sorry, Sam, I don't really know Dan.
It's okay.
Dan, in addition to being just a veteran in law, is also currently sits on as an adjunct professor of law at NYU Law School, and is also the head of the venture group at Mintz Levin. Dan, myself, and Oren Herskovitz from our office have been talking quite some time on how to integrate and sort of help startups get off into the market faster. One of the ways is to understand everything about the law side of things as well as the venture side of things when it comes to startup. And so firms like Mintz Levin offer, I think, great packages for startups to get them off the ground. And because they're very knowledgeable of a number of specific topics, such as what Dan will speak about today. So, I'd like to hand it over to Dan. Thank you.
Thank you. Thank you, Satish. Thank you, everyone, for joining us. Delighted to be here at Columbia. I hope you all got something to eat. How many of you are undergraduate students? How many are in the grad school? So engineering? Anyone from medical school? Okay. Anyone who's a professor? Great, great. Okay, so Satish is right. This is a wonderful time to start companies. The city's supportive of it. Universities are supportive of it. And we're going to talk a little bit today about some things you should think about when you start a company. But first, I'd like to introduce my colleague, Sam Effron. Sam is my partner in crime at Mintz Levin. We work closely with many, many companies from concept to exit, from the very, very beginning, helping structuring, working, networking, working with your ideas, thinking of ways to make you create value, and that's what we do. You want to get to the... So this is from the New Yorker, and it says, never ever think outside of the box. Now, I have 3 cats at my house, and it's the thing that I first start with for my cup of coffee, is never ever to the cats, never ever think out of the box. Unfortunately, one of them, Atticus, generally does things out of the box. But we are humans, we're not cats, right? So we have to be creative. Our job is to think outside of the box. We're not cats. And so it's really important when you start a company is really, there's no one right way. People always say to me, okay, how am I going to do this? What's the right way? And the answer is there is no one right way. We're trying to come up with new ideas, disruptive ideas. One size does not fit all. And we're going to talk about today the different ways you get a company financed. So when you start a company and you start putting together your deck and your business plan, and you start thinking about how am I going to network to get the capital I need to feed the operations of my business, because I have ideas, I have a business, and I'm thinking about how I'm going to raise capital. So, who were the two undergraduates here? I think I saw. Your name?
Avi.
Avi, and yours?
Vincent.
Okay, so let's assume Avi and Vincent are going to start a business, right? And so Avi and Vincent, Avi, what's your major?
Computer science.
Computer science?
Econ.
Econ. So, okay, so let's talk about computer science. And let's look at a business that has existed for all the beginning of time, tutoring, okay? Tutoring started way back when, person to person. And I can show you how it's evolved so that in the early 2000s, people started to do tutoring online. And there were many successful companies such as tutor.com, where you connected a live tutor to a live person. But Vincent and Avi have another idea. They're saying, well, it's time that we connect a student to a computer. And perhaps we call this company AItutoring.com. Okay, so you're thinking about a new idea, disruptive idea, AItutoring.com. And you say, okay, I need to get some money because I have to hire some people. I have to do some programming. I have to figure out how to build this business. We're not going to have revenues for a while. And so I need to figure out how we're going to get from startup to a sustainable business. And so you start looking at my choices. And my choices are, I find capital, and I'm going to find capital, and they're going to come in one of three ways. They're going to come in as equity, like stock, common stock, preferred stock. They're going to come in, or they're going to come in as debt, convertible promissory notes. Or they're going to say, not sure I can do either, your investors, and there's these funny things called safes and other things that some of the incubators out west have created. This session today is not about whether those are good or bad. We have our own opinions at Mintz Levin that they're not the best thing for the ecosystem. But today we're going to talk about why debt, why convertible debt, why are so many companies early stage financed with convertible debt? Okay. So let's talk about the benefits of convertible notes. Number one, it's simple. It's a simple promissory note. Someone gives Vincent $100,000 to his entity, whatever entity we create, and the entity promises to pay it back. Secondly, so there's not a lot of legal costs. There's not a lot of friction. It's an understandable instrument. Secondly, and most importantly, there's no need to value the company. So Vincent and Avi have this company, AItutoring.com. And think about it. Are there any revenues yet? No. So how do you value a company that has no revenues? How do you do this? Can you do a multiple of EBITDA? No.
I just say I'll give them the best deal. When we do come up with a valuation, I promise to give them the best deal, and that's how we do it.
Exactly. You say, I'm going to loan you the money. I'm the investor. I'm going to loan you the money. And when you have a certain amount of equity coming in, someone who's really ready to invest, usually an institutional investor, but it could be a group of angels, then that loan will be converted into equity based off of a discount of that new round. And so what's the advantage of that? The advantage of that is that you don't have this long drawn out discussion of the valuation of the company, which you're never going to reach because Avi and Vincent think their company's worth $10 million. It's clear, right? It's a disruptive idea. Maybe it's worth $100 million. Maybe it's a unicorn, And savvy investor says, well, maybe it's worth, a couple $100,000. Maybe I'll give you $500,000 and I want half the company. So how do you bridge that gap? You say, okay, let's not conclude that argument today. Let's get this company rolling. Investor gives the money for the debt. The company gives a convertible note. And by the way, Mr. Investor, you're going to have a benefit. The benefit is, since you came in early and you're taking the risk, we'll discount when you convert to an equity round, when the real equity comes in, you'll get extra shares. And those extra shares are one of two ways. One is usually a 20% discount. That is generally the market rate. And the second thing is that you may actually get extra warrants. Does anyone know what a warrant is? For those who don't, a warrant is an option, which basically says you have the right, the investor, to invest for more shares. And so today, we're going to go through what's involved in a convertible note. Now, just to reiterate, to summarize again, the benefits of the company is low cost, clearly less transactional costs than trying to do an equity financing. Even a plain Series Seed will generally cost the company more than a simple note deal. 2, no need to value the company, so you avoid that discussion of bid and ask. From the investors, low cost, so their money's not being used to pay us, lawyers. 2, I didn't point out, they're senior to any equity. They're senior to Vincent and Avi. So if the company doesn't make it and there's a need to liquidate the company down the road, 18 months, 2 years from now, theoretically, the debt holders get their money back. And it gives them some leverage down the road on a negotiation, even if there's not any money to come back. We'll talk about interest and discounts. And again, we'll talk that they are a creditor of the company. Sam, should we flip?
Sure.
So at this point, I think you all have a handout.
Yep. There
Yes?
should have been a handout on everybody's chair, and if there's not,
you don't-
there's extras floating around. Does anybody not get one?
Before we proceed, are there any
There's
questions?
a few extra
Anyone
up here in
have
the front row.
questions? Yes.
It might be off topic, or you might cover it later, and if it is, we can talk offline. But to your point, let's say he wanted to hire a couple of people, and he does a convertible note, and there's no value for the company, and he needs to price the stock options. Can you do them later, or do you have to price them at the time of the note when there is no known valuation, and he doesn't want to pay someone to do a formal valuation?
Yeah, that's a great question. And typically that's actually a great situation for the employees. Because you could argue that the company has very little value, and the board of directors of this entity could take the position that the options for the common stock that someone will get has very little value, and theoretically you could do an option at a penny a share at the very beginning. Now, after you get into operations within a year, you're going to want to hire an expert because there's certain rules on that about creating a valuation. But in that early stage and when you start, very common to issue options at a very low exercise price, as low as a penny or 10 cents. Okay, are we?
Yeah.
So, Sam, I'm going to turn it over to you.
Great.
And Sam, why don't you walk through the term sheet? And and by the way, if you have questions, please interrupt. It's better if you ask when you're thinking of it. Oh, yes.
What's the difference between a warrant and a stock option?
There's not really any difference. They're essentially the same type of instrument. It's an option to purchase at a set exercise price.
A stock, just a supplement, a stock option is something that is given to employees, and there's certain rules that are tax advantage if you do certain things, and there are incentive stock options and non-qualified stock options. But a warrant is really economically the same thing. It's a certificate that says you have a right to invest in this company at a set price for a set period of time. It's not subject to the option plan rules, but effectively it's the same thing. So often people who help you raise money or friends or consultants, you will give a warrant because they're really not eligible for the stock option plan.
Okay, because we have a big project, and I had a girl going to law school there for a 4th law degree. I don't know why anyone needs 4 law degrees, but you know, it's like an addiction with some people. But anyway, you know.
It never hurts to be overeducated.
Well, I don't know. It could create a little bit of a holdup. But anyway, you know, the situation I have is that, you know, we've got a bunch of engineers that teach at MIT and Stanford, and they don't want to work for money. They want part of the company. And then I got people in-house that want things. And, you know, like she had a lawyer, he was a partner at one of these firms, and, you know, he was telling me, well, you don't give anything out until I set up an employee stock option plan. So he said, you know, we got, like, I did 2 filings with the SEC. I don't want to get into trouble and do something prematurely. I mean, what am I allowed to do at this point to motivate people? If I go into a meeting, I'm not allowed to tell them, look, I'm going to give you so many stock options because I don't have a plan in place. I guess that has to be filed with the SEC. So what am I allowed to do?
Well, we should talk offline, but
okay.
the short answer is actually you can promise to give people equity. You can do it outside of a plan, and there really, I think some issues are being conflated here. But let's talk afterwards.
All right.
Okay,
Thank you.
great. Yes.
And I've been to different venture capital firms, and I noticed that they always say, like, if there's a Series A, like a first round, second round, third round. In the first round, if you're a seed, they don't give more than $250,000. But then I've met people who've done debt financing, but I don't know if it's a convertible note, and they can do up to $2.5 million, but then it's paid back in 12 months. So with convertible notes, can you be, you know, like, how do you know, or how can you gauge when you'll be ready to pay it back? You know, or
So we'll get into that in the maturity. In this term sheet, and in terms of seed A, B, there's no rules that say you can't call this security a Series Seed if you're raising more than $250,000. Lots of companies in their first round of financing might call it a Series Seed and raise $1 million or $2 million. Those are more just nomenclature and convention. And in terms of debt financing, there are different types of debt financings. There's more traditional bank financing, which, again, the period of repayment is a negotiable term. There's no rules that say that you can only borrow for 12 months or something like that. And as we'll see here in the note term sheet, the period of repayment is also negotiable. So what we thought would be a good idea, just so everybody gets a sense of how these things work, is to go through a sample term sheet, and we'll go through section by section and explain exactly how a note financing will work. So, and again, as Dan said, this is best interactive, so as we go along, if you have questions, please don't hesitate to raise a hand.
And this is what the company would give, or the entrepreneur would give a prospective investor. And then that prospective investor will often give it to his or her attorney. So this is actually a real term sheet, real live, that you would use, that if you would work with any law firm, they would say, okay, hand this out with the form of note, and then there's a negotiation.
So I'm just going to go through each term. Some of these things are I think, more self-explanatory than others. The issuer is the company, right? In our example here, it's AItutor.com. That's the person who's going to be essentially selling to their investors this note security. The amount to be raised, this is, how much do you need? Do you need $500,000, $200,000? You can add a maximum amount to give your investors an idea of the range that you're looking for.
Let me just add, it was interesting, the question. Is it 250? Is it 500,000? In a sense, you should look to see how much money you need to reach a certain milestone so that you can operate your business, or you could raise more capital. In a perfect world, it'd be enough capital to get to self-sustainability. That would be highly unusual in most startup companies. So you really need to figure out how much money you need to give you enough runway to create enough data points that you can raise real equity. And for some companies, that's $50,000. For some companies, that's $3 million, depending on what industry and your expertise.
Mm-hmm. The type of security, that's what we're talking about today. These are convertible promissory notes. The investors. The one thing I want to point out in this section is this term required purchasers. And that comes in later on when you might have certain things that are going to require, if you need an amendment after you've sold the notes. Well, we want to change the maturity date, or we want to change the interest rate. And often investors will want to have some kind of protection that the company can't do these amendments on their own. And they'll set a threshold, meaning usually it's a majority. So if you sell $100,000 in notes, you need folks who hold at least 50,001 cent in order to amend. So that's what the required purchasers concept is getting at. Warrant coverage, as Dan mentioned, warrant, a lot of times you'll hear the phrase warrant kicker. It's like a little bonus for investing. You won't always see a warrant. That's why this section's bracketed. Some financings will have that as a feature. This will typically be introduced as a term by the investors themselves, because obviously the company wants to try to give away, and the founders want to try to give away the least amount of shares for the money. The investors want the most amount of shares. The investor will say, well, I'm going to give you this money, and I appreciate all these other goodies like the interest that we'll talk about and the discount, but I also want my share. When we have a financing later down the road, I also want some additional shares because I'm giving you my capital to use now. And warrant coverage, it just means there's a lot of ways you can calculate it. It's usually a percentage. If it's 100% warrant coverage, it means that if my note at the financing, at the equity financing, converts into 100,000 shares of preferred stock, I'm also going to get another 100,000 shares of common stock. That's 100%. If it was 50% coverage, I would get 50,000 shares of common stock. It's a percentage of the shares that you're getting from the note would then be applicable to the warrant. And as Dan said, the warrant would just be essentially a piece of paper that says, at some point in the next 5 or 7 years, if I want to buy up to this number of shares, I can pay the company this price, a negotiated price, and you'll sell me some more shares at this price. It's a good deal for investors because often that exercise price is low, especially at an early stage, right? I can buy 100,000 shares for $1. And in 5 years, when the company has accreted real value and the value of the company has their shares at $10 a share, that's a great deal, right? You're getting a great deal because you're in at the ground floor. Sure.
But by putting that strike price down, don't you do some kind of valuation? Because you're putting the strike price for the warrant at the time of doing the convertible note. So aren't you implicitly kind of doing some kind of valuation of the company?
There may be an implicit valuation, and we'll talk about that too when we get to the valuation caps. So if you're negotiating warrants or if you're negotiating a valuation cap, there may still be some element of a conversation between the investors and the company about what the company is valued at.
Let me put, sorry to interrupt.
Go ahead.
Let me put it a different way. As the company, you would never send out a term sheet with a warrant provision in it. But for those of you who are investors in this crowd, I don't know if you are, you would come back and say, I'm about to give you $100,000 and I want an extra kicker here and I want a warrant so that I can continue to buy this stock. And we'll do it one of two ways. Let's call the warrant a penny. So basically I'm getting free shares, which is how it's often done in the first round. Or I want a warrant and it'll be priced whenever there's a qualified financing. So when you do the equity, I want to make sure, and that's actually how we would come back as we represented you, the company saying, okay, we get it, you want an extra kicker, but a penny a share is really just dilutive and not fair and not reasonable. But we'll tell you what, we'll give you some warrants to come in now and we'll price it down the road. And that's usually how it works out. Sorry.
No problem. I'll get into your question about valuation when we talk about the cap, because there is a discussion to be had about that. Closing date, that's just telling your investors when you expect to close the investment. You can set a minimum raise as a threshold, meaning, you're telling your investors, we won't close on anybody until we raise at least $100,000. You don't have to have that. Sometimes folks want to know that they're not the only one coming in. Interest rate. Now, interest rate, the market rates right now, I see generally between like 4 and 8%, usually around 5 or 6 is kind of the median. This is just an additional benefit for the use of capital by the investors, right? They're giving you the money. It's a high risk investment. They could lose everything. They might not see any returns for 5, 7, 10 years. And so for the use of capital, there's a little bit of a bonus, a benefit here for the investors. And that interest, we'll talk about this later too, will also be converted, most often will be converted into shares at the qualified financing. The maturity date, this just tells you how long the company has until they have to repay these notes. Typically, we see between 12 months and 2 years, 18 months. Enough time, the company's going to want to have the longest period of time possible, 2 years, 3 years, right? So that they don't actually have these notes as due and payable before they raise their money. Oftentimes, if you get to a maturity date and you haven't raised your money, there's one of two things is going to happen. One, you're out of business already anyway, and then the note holders can try to sue on the notes if there's anything left in the liquidation. Or if you're really close to reaching a new point where you can raise money, you'd more likely go out to your investors and say, hey guys, we hit the maturity date, we need another 3 months, can we amend the notes so that the maturity date is extended? Use of proceeds is just generally telling your investors how you're going to use the money. More often than not, this is just a general sort of a general corporate and working capital purposes. Sometimes if you've got a savvy investor or if it's a significant amount of money and there's specific milestones that they want you to use the money for, they might specify in the negotiation what you can use the money for specifically. Prepayment is just saying that the company can prepay the notes without any penalty. And then a security interest is basically it's a filing you can make to say that I'm going to have a claim on the assets of the company. Most often, convertible promissory notes are unsecured. So if there's a default, the most that the investors can get back is their money. They can't make any claim on the assets of the company.
In most software companies, it's unsecured. I have seen it in life science companies where someone says, look, or companies that have really particular valuable patents and there's people loaning a lot of money, like millions, they'll say, look, I'm not going to give you $1 million or $2 million unless I have a secured interest in your assets, including your intellectual property. But these are really big plays. I mean, these are sophisticated investors and big plays, as I said. So and what that means, just to supplement what Sam says, is that note holder who has a security interest is senior to any other debt and has a right to grab those assets after it goes into court and gets a judgment, all that. So if you're representing professional investors who are loaning lots of money, they might ask for a secured interest. In a typical startup, emerging companies, trying to do this frictionless, cost-effective, there's no security interest. You're just loaning the money and getting a note.
I've seen people, I actually saw a bank do an unsecured loan for $42 million. And
Can you give me the name of that bank, please?
No, they ended up in court.
And I'll tell you, I've seen banks try to give secured loans and not do the filing properly, and then try to foreclose on those assets and not be successful. So as soon as you get into this area of secured notes, the investor needs a lawyer, needs a sophisticated lawyer, and they need to make sure they get it right because they may not get what they really think they have.
Yeah, there was a deal in Europe recently where someone bought Volkswagen. One of the big car companies bought Volkswagen, and the lawyers forgot to put the trademark rights in there, into the contract, and the people that bought it couldn't use the name. It's like crazy stuff happens.
Stuff like that happens. Yes.
Yeah, I have a question about prepayment.
Yes.
So, I mean, can you explain again? So it basically, do I understand correctly, it means that you would pay the investor the money back before the maturity of the loan, and they would not get any shares at that point?
So yes, that's how it would work. In practice, this never happens, right? A startup company is not going to take $200,000 of its capital, if it has that capital, to repay these loans.
Right, and you could convert into the equity.
And the investors is
about
more
change of
likely
control.
going to have, the investors is also going to likely have an optional conversion, so that when you say, here's your money back, they say, no, I'm going to convert it. I know you haven't hit your target yet, but I also have the option to convert into equity. I'll do that instead.
Okay, because
And-
otherwise I could set up a deal that I find another investor and just prepay them 2 days before maturity, and they wouldn't get their stock, or, I mean, don't they have some I don't understand.
Yes,
prepayment
but-
in the sense, don't they have some guarantee that it will convert?
We'll get to that.
If you look at change of control, you're stepping ahead, but we'll get there. Change of control,
Well, it's
there's
really
protections.
voluntary, because
Yeah.
it might not be a change of control. It might just be that they have the cash. But we'll get to that, and I'll explain how that would work. Future indebtedness, this is not it's bracketed because this is not a term that you'll see in all deals. It's basically just the investors, this would be an investor-friendly term, saying you can't take on any other debt without our permission, essentially. The qualified equity financing. So this is where we get into the real meat of the note. And this is where the investor's money turns into equity in the company. So a qualified financing, this is going to be the trigger event that takes your money that you've loaned and turns it into stock. And this is the threshold is a point of negotiation. Usually in early stage startups, it could be as low as $500,000. Often it's $1 million or $2 million. So the investors want to make sure that it's a real, a significant and bona fide investment that's going to turn their investment into stock. And what that means is that when the company goes out and says, okay, we're ready for our Series Seed, or we're ready for our Series A, and we're going to raise $1 million. When that closing happens, right, they negotiate they get a whole nother set of investors, maybe it's the folks who lent them the money. But let's say they go out to a venture capital firm, and this firm is going to make a $1 million investment, and they negotiate the terms of this new stock in the company, let's call it a Series Seed preferred. And the company and the firm have negotiated all these terms, all of the rights, all of the goodies, the way that the investors are going to get their money back at the end if the company is sold or goes public, if they have board rights, all of these terms are negotiated, and that's the equity financing. When that equity financing closes, if it reaches the threshold, if our threshold, our qualified financing is $1 million, and the company raises $1 million, that's when our notes convert, right? If we have $1 million threshold and they raise $200,000, our notes are going to stay out there. They're going to stay out there, and they're going to wait until they raise $1 million. So that's, and then also sometimes you'll negotiate whether the amount that they have to raise is on top of what they raised in the equity financing, or if it's in addition to. So if it excludes the notes, then you need, let's say it's $1 million, you need a fresh $1 million. If it includes the notes and you raised $500,000 in notes, you only need to raise $500,000 more in equity to trigger. So that's when our notes are going to convert, and that's the primary means of a convertible note converting into equity, is this financing event. We'll talk about a couple other ways that it can convert, but this is what the investors want. They want preferred equity, and then we'll talk about this. So the next section here in the brackets, into what does it convert and at what rate? So very typically there's a discount, and the vast majority of deals have a 20% discount. And what this means is the equity financing, which is being negotiated between the company and the venture firm, they have gone through the process of valuing the company, setting a value, and then finding out what the price per share is going to be for the preferred. The way you do that is you negotiate over the value, You find out how many shares are outstanding in the company on a fully diluted basis, meaning if everybody converts their options or exercises their options, exercises if there's any warrants outstanding, if we issue all the shares in the option pool, if we have an option pool, how many shares is that? That's the fully diluted capitalization. You take the pre-money value, you divide that by the fully diluted capitalization, and that gives you the price per share. And let's say, just to make things easy, the price per share is $1. So when these equity financing folks are going to buy their Series C preferred stock, it's going to be $1 per share. And the debt holders are going to convert at a discount to that, meaning that their principal plus their interest is going to buy shares at 80 cents a share. That's the discount. You buy the shares essentially at a lower price.
So they get extra shares.
They get extra shares. Now, there's different ways to handle these extra shares. The most common way to handle it is that your whole principal plus your interest is going to just buy shares at this discounted price. Sometimes, and this is becoming somewhat more common, your principal will buy shares at the discount, or your principal will buy a certain amount of shares, and then the discount and the interest will buy common shares. And the reason why that is starting to come into vogue is that, let's say I put in $100,000 into a note, and then there's an equity financing, and I'm just going to keep these numbers easy. Somebody else puts $100,000 in. And now we are the only two holders of this Series Seed. Now, equitably, we should own 50% each of the class, and when the company is sold, our class should be split between the two of us, 50-50. The way it actually works with this discount and interest is that I'm going to have what's called $120,000 in interest, and my discount, and the math is wrong, but let's just do it for purposes of making things easy, is going to result in me having $200,000 of shares. So even though I put in $100,000, I now have 2/3 of the class. The way some folks have tried to address that is by taking that extra chunk of shares and issuing it as common, so that just as between the note holders and the equity holders, it's pro rata in their actual invested dollars, and then the note holders do get this extra bonus shares, but just in the form of common stock. And that's a bit of a complicated sort of concept, so if anybody has any questions on that, feel free to jump in. Now, sure, go ahead.
It just seems like this is an area where there may be some opportunities for gamesmanship.
Mm-hmm.
And I'm wondering if you can give just a couple of examples of how this maybe needs to be expanded to try to head off some of that, or where some things would slip through because it wasn't well written. I mean, just by way of, I'm just thinking off the top of my head, you get some friendly investor to come in at just below the conversion amount. So if let's say it's $1 million, they put in $990,000 at some equity, which results in some, valuation of the company. Then they put in another $20,000 at a lower valuation, which now converts the original note at this lower valuation. It just seems like there's
Well, remember, you don't have to accept the capital. You don't have to, as the company, you don't have to participate in that gamesmanship. And you as the company don't want to dilute, the company doesn't want to be diluted because they're the founders. They want to make sure they're raising money at the highest valuation. So I have to tell you that I haven't seen, it's funny you say that gamesmanship. We really just don't see that. If someone wants to build a company and put in $1 million, they're going to put in $1 million, and they're going to accept that someone else put in the money earlier and it's going to have a discount and get some extra shares. If they at the time of the equity financing, they don't like the valuation they're putting the money in, they're going to say, I'm not putting it in at that valuation. This is what I'm willing to put it in. So I haven't seen that type of shenanigans on that micro level, really.
Yeah.
I think the big issue really becomes, as Sam was pointing out, just to supplement a little bit, what happens is how you handle the waterfall on a sale. And so if you're buying shares at 80 cents a share, so instead of having, in the example, 100,000 that you get back off the top, you get 120,000 off the top because you had those extra shares. That's where the equity people say, well, that's not quite right. I put in 100,000 and you're getting 120,000 at the same time. I want your extra 20,000 to come after we split the first 100 each. There's some issues on that. It's really not a big deal. If I'm an angel investor, I actually want it all as the preferred. If I'm coming in those convertible notes, I'm really not willing to take it as common. And the only time I've seen that pushback really is when you have a really sophisticated equity player who's a VC who is really looking at the waterfall on a very micro level, and they may ask the note holders to deal with it at that point.
Thanks.
Yep. So there's one thing I wanted to cover, and we mentioned this before, the valuation cap. Again, this is a negotiated term. You won't see it in all financings. Sophisticated investors will ask for it. But from the company side, if you're representing a company or if you're a founder, you don't want to offer a term sheet with a cap because it's not to your benefit. And the way the cap works, it's essentially another type of discount. That's the easiest way to say it. It's basically saying, well, let's put a flag in the ground and say that if the company is worth more than X, we're going to get additional types of discounts. So the way that it works in practice is that I'm going to get a discount that's the greater of my 20%, or what would result if we said that we're going to freeze the valuation of the company at $3 million today. And that may involve a negotiation about what that number is, but maybe not to the same extent as in an equity financing, because it's really just putting your finger in the wind, essentially. And if the company knocks it out of the park, and when they get to their qualified financing, it's valued at $10 million or $20 million, my price per share is still going to be calculated at as if it was valued at $3 million. So you can end up with a significantly greater than 20% discount. That's the practical effect.
And the reason this has evolved is really recently, and the reason being that we've seen a run-up of valuations of private companies. We've seen a run-up because the IPO market isn't so robust. We're seeing companies that are having really astounding valuations early on. And so, having talked often with the investor community, they say to me, look, I'm happy to be an angel investor. I'm happy to get my discount, but I'm really not giving this high-risk capital so that it's converted at a $100 million valuation. So we have to come up with some reasonable cap, and I know we're trying to avoid valuation. Like, one of the reasons we're doing convertible notes is so we don't get in this argument about valuations for a revenue-less company. But honestly, I'm not giving anyone $100,000 if they think it's going to convert at a $100 million valuation. That's just not why I'm giving this money. And so that's usually what happens. And the cap is actually usually higher than what the investor would really think it's worth. It's really like you're saying, look, I'm protecting myself that you have some crazy person who comes in and overvalues it, yes.
So just to add to that, I'm a member of an angel group, and we never do notes without
A cap, right.
And part of the reason is what you said, but the other reason is, let's say the discount's 20%, and most of these notes are for 1 year. As an angel investor, I'm not looking to make 20% in 1 year. You know, I'm gonna either make 0 or a huge percentage in 1 year. So 20% is just not enough incentive without limiting the cap.
Good point. Does anybody have any other questions on the qualified financing conversion? Because I'm going to move on into the other different types of conversions. So, voluntary conversion, and there's a couple different flavors of voluntary conversion. One is on what they call a non-qualified financing. So what gentleman in the middle there was talking about, where we're raising money and it's not $1 million, it's $500,000. You can give the investors the option to convert into that, or they can hold on to their notes, right? Because they may say, well, I'm going to have a better position if I wait until a real financing. They'll get some cash. It'll extend their runway a few more, another year or two, and I'm going to just hold on to this debt because I'm going to be better off if I convert into the next more senior financing. Another type of voluntary conversion is if the investor just decides to convert into common, right? This is in a lot of term sheets. I've never seen it actually happen because from the investor's perspective, they're either going to want to wait until there's a conversion so they have a preferred security, or the other alternative is that the company goes out of business and you want to be first in line with the other debtors. There's not really a good economic incentive for the investors to convert into common stock to a company that's not going anywhere. But you give them the investors the option. Change of control. This is the goal for a founder. This is the exit. This is the sale. And either you're going to have an IPO and you're going to sell your company, your shares publicly, or you're going to sell your company to a bigger fish. And if the notes are still outstanding when this thing happens, and sometimes they are, if you've got a company who's made really good use of the funds that you loan them in the convertible note round, and they turn that money into great employees and generating revenue, and they get to a point where they're actually a real viable target for a large acquirer, there could be notes still outstanding. And what happens here is that the investors are usually given some kind of, they're given an option, either a multiple on their investment, so you're going to get back 2x or 3x or 5x on your principal. You loaned me $100,000, and at the change of control, we're going to use some of the proceeds to pay you back $200,000 or $300,000. Or they can convert their shares at a valuation so that they are stockholders in that acquisition, and they're treated as stockholders at the time, and they'll get proceeds. So it might be that I would be paid back. I invested $100,000 and I have a 2x multiple, meaning that the company's going to pay me $200,000 to pay off my note, or I might be better off converting it into common stock because I'm going to get $400,000. But you give the investor that option. And those are negotiable terms as well. Events of default, this is just ways in which you can perfect. These are things that happen to the company that allow the investors to go into court and say, pay me my money, right? So you file bankruptcy. That's sort of the most common one, for example. You don't pay back. The maturity date is December 31st, 2018. Company hasn't raised the money, and they also haven't repaid the note. Well, I'm going to go into court and sue because now you're in default on this note. In practice, that doesn't really happen. But this protects the investors so they can go in and sue on the note if there's something adverse has happened to the company. Amendment and waiver just tells the investor how we can change the terms once we've already entered into the transaction. The expenses section, sometimes a savvy investor will negotiate for the company to actually pay some of their legal fees. If you're the company, obviously, you don't want to have to do that. If you're the investor, you don't want to have to come out of pocket to have your lawyer look at all the documents. And then investor representations. Each investor has to be an accredited investor. This is part of the securities laws, the Securities Act. Debt instruments, debt securities are securities for the Securities Act. That means that if you're selling these securities to folks, they have to be accredited investors. That's for individuals, they have to make at least $200,000. I'll get to you. That's either $200,000 for individuals as income, gross income for the year, $300,000 for folks who are married and filing jointly, or $1 million in net worth. There's some other categories for entities or officers and directors, but those are the basic parameters. If you don't fall under those parameters, you can't buy these securities. The company should not sell you the securities because they would be in violation of the securities laws.
Well, I'm going to disagree with my colleague here because that's the best thing about lawyers. We can fight with each other. Many companies start with friends and families who loan them money who may not be accredited. What that means is that you're not going to fall within the safe harbor that the SEC points out. And generally, if you're doing a note offering with a law firm where you're going to multiple people, you're going to want to be in the safe harbor so there's no issues that the SEC is going to investigate later or when you bring in VCs. But I will tell you many companies, and if Abi and Vincent want to start a company and they have a roommate come in and give them money, they'll do so. I mean, I can think of Facebook, for example, where Eduardo Saverin loaned $15,000, or actually invested $15,000 with Mark Zuckerberg, and I can tell you Eduardo was not an accredited investor at the time. So it happens, and it's not a terrible thing. It's like jaywalking. You're not going to get a ticket. And it is actually okay to do. It's just a question of down the road, if you're doing these types of large securities offerings, you want to hit a safe harbor.
Fair point. So, right behind you.
Yeah.
But now you can also do a Title III under the Jobs Act as
Yes.
an unaccredited investor.
Yes.
So the laws have changed now to that. So you really
They have.
that option.
They have, and that's true. You could do a Title III crowdfunding offering, in which case this term would not be
Don't
included.
you have to do a private placement memorandum for that?
Hold it. Come back next time. We'll do a crowdfunding Title III. It's not so simple.
Yeah.
It should have been simple. When it was proposed originally through Congress, it was simple. By the time it got through the Senate, it was not so simple. And believe it or not, there's a lot of ends, ifs, or buts that make it more friction and more transactionally expensive than what we talked about today. And it's really not going to be very good for someone who wants to build a big business and wants to bring in institutional investors. But we'll be happy to talk to you offline about what works with crowdfunding and what doesn't.
I would like to be included in this conversation. I'm from an equity crowdfunding platform based out of Ireland.
Oh, great.
I'd love to hear what the
Great.
American perspective on that is.
Love it.
Great.
You mentioned safe harbor. Can you give some more context to what that means?
Okay, so anyone can do a private placement, which means I'm just talking to you when we have a relationship and you give money to one party and we give you shares, and that's exempt from the rules of being a registered offering and a public offering. What the SEC has provided in rules and regulations is, well, what does that mean that it's a private placement? What does that mean that it doesn't have to be registered? Because remember, in the US, to offer securities, whether it's equity or debt, that offering and the securities that are being offered either has to be registered with the SEC, which is an expensive, long process, or it has to be exempt. And they provided in regulations, principally in something called Regulation D, a safe harbor, which says if you follow these rules of Regulation D, then you can rest assured that it's not a public offering. And so whenever you're doing institutional offerings or doing big offerings, we as lawyers, especially if we have to give legal opinions, say you really need to do it within the rules of the safe harbor if you want to be completely crystal clear that you'll never be subject to any SEC issues. Any other questions?
Are you subject to SEC review?
Who?
For which kind of offering?
You just said you'd never be subject to any SEC issues.
Yeah, you would not. For if you comply with the safe harbor, there is no review by the SEC. So that's good. So
you would have to file what's called a Form D, which is
a notice filing.
It's a very short form description of your offering with not a lot of details, but that's.
And it's a mere notice filing. It's not a review. It's not a merit review. It's not a review. It's an after the fact filing, and I think they do that as much just to collect data. The SEC really is not particularly focused on this early stage offerings. It's just not a big issue for them. They choose really not to focus on it, and that's why you have things like Theranos. They start early and they grow big and no one ever focused on it until there's a big problem. They worry when there's a big problem. And the lawyers who are in this field want you to comply and go through the safe harbor so that you don't have problems. It's better not to jaywalk, as I would say.
Yeah, I mean, from what I read, Zuckerberg did a lot of informal accepting of money from people. A guy he worked for upstate, he was fixing the guy's computers. He loaned him $3,000. Now the guy claims he owns more than half of Facebook. And then Google had.
Well, that was thrown out of court, but that's it.
Oh, it was? But
yeah.
Google had a whole bunch of unaccredited investors. And
yeah.
I heard the SEC came down on them and they had to fix that. So, yeah.
You'd rather not have those problems.
Yeah.
You'd rather not have those problems. So we'll wrap it up because it's time. I would like all of you to, if you have questions, go to our website for emerging companies. It's called MintzEdge, MintzEdge.com, and it's a resource for entrepreneurs. I think it's very helpful. There's a lot of material there. And of course, you can always reach out to Sam or me. Our emails are on that website, MintzEdge.com, and we'd be delighted to follow up.